Good evening. It's time for our third session of the conference, Current International Legal Regime of Natural Resources of Celestial Bodies. This session will hold, as I have been informed, the whole session will be held online. And I will call Professor Dr. Maida Bećirović-Alić.
Yes, she's here.
Can we hear each other?
Yes, I can hear.
She will present its paper named Legal Regulation of Commercial Use of Celestial Bodies in Space.
Svetlana, zašto ide ovaj mikrofon? Aha, okay.
Oh, please take the floor.
Thank you very much. Dear participants, we are pleased to be part of this event today. Considering the topic of this conference, it is difficult to say something new that my predecessors haven't said, but we will try to present you an hour overview of this topic. Space law is a branch of law whose development began at the beginning of the 20th century, and which, with the increasingly rapid development of space technology, it becomes more and more important. The first discussion on the problem of regulating space law began shortly after the first successful atmospheric flights, because it became clear to many legal theorists that the sky is no longer the limit, and they began to consider the legal problems that may arise if man truly conquered the universe, in this case, the space. Human activities outside the borders of the planet Earth raised the issue of legal regulation related to the human actions in space. So the launch of the Sputnik 1 in the 1957 resulted in the formation of the Committee for the Peaceful Uses of the Outer Space by United Nations, which undertook a series of activities aimed at the legal regulation of space exploration, the most important of which is the adoption of the so-called space agreements. The most important treaty that regulates law in space is the Outer Space Treaty, which, although it was adopted in 1967, still represent the source of regulation of all activities related to the space, and is often called the Space Constitution. The above treaties have been accessed to by most of the member states of the United Nations, except for the Treaty on the Administration and Activities of the States on the Moon and Other Celestial Bodies from the 1979, which prohibits any commercial activities on the Moon and other celestial bodies. The Treaty on the Moon reiterates that the research and use of the Moon are the heritage of all humanity, so all countries should benefit from these activities regardless of the level of economic and scientific development. Special attention should be paid to the interest of the current and future generation, as well as the need to promote higher living standards and economic and social developments. According to the Moon Treaty, all research on the Moon must be in accordance with the UN Charter and international law and be based on the principles of cooperation and mutual assistance. As we can see, the provision of the Moon Treaty mentioned so far are almost copied from the previous treaties. What makes this treaty different are the provisions on natural resources on the Moon. Namely, following the model of the seabed and the subsoil beyond national jurisdiction, the treaty enables the Moon and the natural resources on it to be declared a common good, and that the exploitation of these resources is permitted only in a manner that will be regulated by a special international regime. And the purposes of that regime will be orderly and safe development of resources from the Moon, rational management of these resources, expansion of possibilities for using these resources, and equal sharing of benefits from lunar resources among the member states. Although it would be an undoubted progress and result of international law, developed countries did not accept it, considering that the country that has invested huge financial and material resources in enabling the exploitation of the resources on the Moon should not share them with others. Precisely because of this provision, neither Russia nor USA signed the treaty on the Moon, because they did not consider such a solution a fair deal. The biggest player in the space, such as China, the US, and Russia, have not ratified it. Neither is Great Britain. With the growth of the private sector in the space exploration, it is less and less likely that the Moon Treaty will be ratified by more states, considering that it completely excludes the privatization of lunar resources, and this may lead to a loss of interest in further scientific research of the Moon. Agreements prohibiting national ownership of celestial bodies have faced additional challenges in recent years. In 2015, the Commercial Spaceflight Competitiveness Act was adopted in America, according to which US citizens have the right to own any resources they find on asteroids. It is true that the law does not apply to the Moon, but these principles can be extended and applied to other bodies. Also, we have the similar situation in Luxembourg. 2017 passed its own law with the same property rights for resources found in space. The desire for research and money is, of course, there, and states seem to be more and more interested in helping companies. The United States of America was the first to take initiative to make some concrete steps on codification and unification space law in October 2020. 8 countries signed Artemis Accords developed by NASA, which has intentions to be new cosmic constitution. The document defines the most general principles and is of an advisory nature, yet Russia flatly refused to sign the agreements and generally to participate in the lunar program of NASA in a secondary role, as they said, and even announced the adoption of the Zeus amendments to the Artemis Accords, with which they will fulfill, as they say, the real purpose of the space constitution in addition. The document created by NASA was criticized even before it was published. And the main problem is, as the critics say, that the US authorities intend to take control of the Moon in the format of bilateral state agreements. The realization of the mission will practically be given to private companies. So, unfortunately, the world consensus failed. Without an agreement on the universal level, we could watch states test each other's patience and race over imagined sovereignties in space, the same way they have done for centuries in Earth, seas, and oceans. Such a primitive approach to these dimensions of discovery can lead to the loss of scientific information or opportunities for data exchange, and this must be prevented from the very beginning. Of course, it must be clear to the entire planet that this path cannot be decided by just a few powerful countries. With the increasingly rapid development in the field of space technologies, more and more problems appear for which the fundamental international agreements regulating the legal regulation of the space can be no longer provide quality solutions. The current body of international law dealing with the outer space, including also that the 1967 Outer Space Treaty provides an important foundation, but is unable to answer all of these questions. First of all, it would be necessary to establish multilateral agreements that will deal with these issues. They also include protocols for resolving conflicts if two powerful players compete for the same resource, or if a company discloses important scientific information that should be available for the public. Finally, we should also think about cultural and natural heritage. The best solution would be to conclude a new agreement at the UN level, of course, similar to the one in 1967, which will be signed by all the great powers and which will regulate all important issues. Maybe that proposal is a kind of utopia, but the professional public has a great responsibility and must really and constantly work on proposals for new effective solution on this very, very important topic. Thank you very much.
Dear Maida, thanks a lot for your contribution to our conference. Now I will call Assistant Professor Irina Štodina from the Moscow State Institute for International Affairs. Can we hear each other?
Yes, I think so.
So please take the floor.
Добрый дан, здравствуйте. Good evening. So, dear colleagues, I thank you for the opportunity to participate today in such a significant and interesting event. My report is devoted on the problems of compatibility of the provisions of the US legislation on national appropriation of space resources with the Outer Space Treaty. My report is devoted to the problems of compatibility of the provisions of the US legislation on national appropriation of space resources with the Outer Space Treaty. It is a known fact that many significant international treaties that have defined the world order for several decades are being constantly revised. The issue of preserving the provisions of the Outer Space Treaties, and in particular the Treaty of 1967, which constitute the so-called Corpus Juris Spatialis, is also raised. As you may know, many key provisions of the Outer Space Treaty, for example, Article 1 on the exploration and the use of outer space for the benefit and in the interests of all countries, irrespective of the degree of their economic and scientific development, and being the heritage of all mankind, or provisions of the Article 2 on the prohibition of national appropriation of space, the moon, and other celestial bodies, as well as Article 4 on the use of space and the moon exclusively for peaceful purposes, have been called into question by some unilateral actions of the USA and a number of the other countries that have already adopted national legislation, which either directly or indirectly violates the treaty. Actually, such a position is not new on the part of the USA. When it is considered that the provisions of the existing treaty cannot satisfy their national interests, they start working on the broader construction of the already existing norms of the international law. The meaning that was not originally put is deduced from the treaty, then the national legislation or so-called interstate law is adopted, and all this is aimed at erosion of the treaty's regime. Thus, the question of maintaining the full force of the existing treaties arises. In such a controversial scenario, possible or relatable with regard to the Outer Space Treaty? To my mind, the answer is far from obvious. First of all, because it is a multilateral agreement with more than 100 member states, and not all of them support US position. Moreover, Article 15 of the treaty itself provides for the possibility of amending the text of the agreement with the consent of the majority of states. Here arise a lot of complex questions. Where are the dividing lines between the interests of the US and its allies and other parties of the existing treaty? Firstly, the US position is based on the fact that outer space should be regarded as an arena of military confrontation. According to Mr. Paynes, today the US participates in the arms race in outer space, as it has been doing since 1960s, and the stakes are only getting higher. Secondly, as all we know, the most complex and, let me say, so dangerous question today is the possibility and legitimacy of appropriation of space resources. I would like to divide the latter issue into two aspects. The first one, the search for the international legal justification of appropriation of parts of outer space. For example, Lagrange points where gravity practically doesn't work, types of orbits which are a limited space resource, turning a part of the territory of the moon where the Apollo landing took place into a national historical park, with the inclusion of such an area in the UNESCO list of historical heritage, according to the Apollo Lunar Landing Legacy Act. It would seem that the solution of the current discussion has already been reached, since the legal status of the geostationary orbit is specified in the international law. It is known that today geostationary orbit is considered to be a limited natural resource. The second aspect is the legality of the adaptation of national legislation by the United States in order to update the possibly broadly construe the provisions of the Article 2 of the treaty. Here the answer is not so obvious, and there are different theoretical views on the essence of the issue. First of all, there is no common understanding of what should be understood by the use of celestial bodies and the use of their resources, whether the term extraction extends to already extracted minerals or to minerals in situ. Should civilistic constructions in general be extended to public law agreements? As for the USA, it is obvious that they have solved the question by adopting a number of national interstate legislative acts. For example, Commercial Space Launch Act, Commercial Space Launch Competitiveness Act, the Executive Order by Mr. Trump of 2020, and so on and so forth. Furthermore, similar national legislation is already adopted by many states that joined the well-known Artemis Agreement. The last state, along with Canada, Japan, and Luxembourg, was the Czech Republic. Thus, the so-called feeling of legal lacuna, legal gaps, if you would like to put it this way, in the Treaty of 1967, with national legislation, can be considered as an accomplished fact. At the same time, nobody considered it was necessary to take into account the will and the intention of all the other parties of the treaty, who always adhere to the traditional legal construction of its provisions. Even more interesting, if I can say so, is the unilateral understanding by the USA of the provisions of Article 1 of the treaty. Thus, the Secretary of US National Space Council, Mr. Pace, emphasized that the USA does consider outer space to be neither the common heritage, nor the common heritage of mankind, nor common property, since these concepts are not the part of the provisions of the treaty. Perhaps the doctrinal construction of the provisions of Article 1 is extremely vague. According to Professor Georgi Viliaminov, the concept of a common heritage of mankind, which is commonly applied in the law of the sea, in relation with outer space, can be considered as more ethical than legal. And at this very moment, there is no doubt that at the time of the adoption of the treaty, many of modern aspects of the use of outer space seemed like science fiction or a dream. Obviously, the treaty could not provide clear answers to all the legal issues of space exploration arising today. It could not be otherwise. So there is there is such a significant number of legal lacunae and uncertainties in the construction of the provisions of the agreement. What follows from this? I'm convinced that all aspects are already resolved by the practice of application of Vienna Convention on the Law of Treaties. First, the principle of good faith fulfillment of international obligations is still the part of international law. You can find the reference to it in the preamble of the Convention and specifically in the Article 26 of the Convention, or in the Article 31 devoted to the good faith interpretation of treaties. Finally, I would like to contemplate on the possible algorithm of behavior for the Russian Federation. It is obvious that the national legislation on the use of space definitely needs to be updated. First of all, the possible greater attraction of domestic Russian companies' capital to this sphere of activity. Whether we will use the US experience remains at the discretion of the Russian legislation. In any case, Russia has to get out of space trench and develop national legislation as to the international law. From the point of international law, we will have a difficult struggle to preserve the legitimacy of the Treaty of 1967 on the regulation of human activities in outer space. Thank you for your attention. If you have any questions, I would like to answer them. Thank you so much.
Dear Professor Štodina, thanks a lot for your very interesting and useful contribution. I will now call Svetlana Popova from the Center for Comparative Law from Shenzhen MSU-BIT University, Shenzhen, China.
First, I would like to thank the organizer for the invitation and a rare opportunity to discuss the most demanding issues of space law and policy. I have to say that delivering the presentation at the very end of our international conference is a great honor and a great difficulty, because a significant part of what I wanted to say has already been said by my esteemed colleagues. That's why I decided as soon as possible to change the structure of my presentation, so I have to apologize in advance for possible gaps in logic. When we discussed our international legal topics, we always stopped before political issues. I think it's normal practice because it's difficult for our legal society to discuss political aspects, especially technologies, without jumping beyond the limits of professional comfort. But Professor Gajić spoke directly that we try to find new political and legal innovations to protect the interests of countries that today don't have opportunity to explore and use space resources. I was very inspired and decided to rearrange the accents of my presentation. I have the opportunity to talk about political issues because I have a degree in political sciences. Also, our Center for Comparative Law, which was established at the joint Russian-Chinese University in Shenzhen 2 years ago, is focused on practical application of legal results in governance. The problem that worries me personally is the ability of science for fast responding to challenges and demands of reality. The question of the possibility of national or private appropriation of space resources arose more than 70 years ago. Today, when this topic became not fiction but reality, we found that there is still no good answers. In my opinion, the criterion of speed is extremely important. We can see that the impact of laws in reality has greatly accelerated in the 21st century. As a proof, I wanted to show 2 slides comparing how fast the legal innovation affect economy in 20th century and today. As you see, the United States Commercial Satellite Act has generated $1 billion in revenue in 30 years, and the Luxembourg Space Resource Initiative has generated the same volume of money in 1 year. In the beginning of our conference, Professor Gajić said, politics creates law, but I would make an addition to this maxim. economics makes politics, politics makes law. And in this slide, I wanted to show the power of economic interests that push changes in the existing legal regime. One little example. In 2021 only, the United States space economy accounted for 211 billion of gross output. This volume is more than the annual gross domestic product of Belarus or Slovakia, as well as more than gross domestic product of 128 countries. Another telling example of why legal initiatives are born quickly is on this slide. As we know, Artemis Accords were signed by 29 countries in one territory. The joint gross domestic product of Artemis Group is more than 65 trillion, or more than 62% of global domestic product. For comparison, our Chinese initiative One Belt, One Road that covered 68 countries today counted only 40% of global GDP only. It's a very powerful force. I based my analysis on the space resource legislative innovation on the approaches of political management and political technologies. My conclusions is following. The chain of legal innovations and different institutional events of 2040-2022 years testified the creating an international legal custom. I have to note it was deliberate and purposeful creation. We can discuss whether it's ethical or not, but its effect. Other experts express the same position. For instance, Dr. Vladislav Leonidovich Tolstoy considers that the laws of United States, Luxembourg, and a number of experts document as a part of reform of international space law to legalize the appropriation of extracted space resources. Here I have highlighted the key components of this political technology. United States and other countries create the precedent. Precedent turns into practice. Practice turns into best practice for dissemination. Then we have formation of a favorable legal opinion, and after we have recognizing on international legal custom. In other words, we see how the countries interested in space resource appropriation shift the Overton window and turn the national legal innovation from unacceptable practice into an international legal custom. In this regard, I would like to note the special role of the building blocks delivered by Hague Group. Formally, this document has no legal significance, even as a soft law. However, we have the kit of solution that is politically useful, because this kit of ideas and solutions ensures the interoperability of sovereign acts in future. The main question, what shall we do? Today we see great mismatch between the pace of real changes and our institutional and legal ability to cope with these changes. In addition, we cannot yet find solution to reconcile equally important but competing interests. For instance, we don't know how to harmonize national interest and common interest of mankind. We don't know how to harmonize need in acceleration of the national space economy and equal access to space benefits. I believe that, as in many other cases, the problem under discussion does not have a legal solution right now. The solution may be found in the field of politics, or rather, as usual, I say, Professor Gajić said, we can talk about the innovative political technologies to find a legal solution. My idea, based on my past practice in federal bodies, is following. Maybe we should stop say about decision good for all, and at the first step, we need clearly describe the interest of countries capable to space resource mining and interest of countries not capable today to space resource mining. In other words, I propose to separate before they unite more strongly. I think it may be difficult to find a common position for countries that are not capable today for space resource mining. It's a real problem because each country has its own idea and interest. But the algorithm of acting is delivered on this slide. Maybe as a fantasy, we need to create the institutions in interest of non-space mining countries. After we need to find inner agreement, what solution will make us happy. This decision, this agreement provide help us to find the good choice of political and legal instruments to promote joint positions, and after we have to coordinate our collective actions at all levels, from international to national, to promote joint interest. As a conclusion, I would like to make a few notes on the impact of legislative innovations. I think the main issue is that now we see a model of a bipolar world, but in space. Previously, it was the space powers and all other countries. Today, we have other two poles. There are countries capable to space resource mining and countries not capable today to space resource mining. Other impacts, I think, if we stop international innovation, we see more national legislative innovation. We will see recognizing the practices in international legal custom, and we will see legalizing the appropriation of extracted space resources, and maybe it would be create new international space regime. In economic, we see that strong economies will become even stronger with this legislation initiative, and developing countries have to seek equitable access to the benefits of space resource development. In policy, we will see, I said, bipolar world in space, and we will see how the political technologies will use to change the international order. And we need, as soon as possible, to update, to improve the effectiveness of the United Nations organisms, the procedure, etc. I would like to say that non-profit, non-government organization and discussion with multi-level speakers, it's a good mechanism to find the solution and to foster our legal initiative for all mankind in this very demanding field of international law. Thank you for your attention.
Dear Professor Popova, thanks a lot for your very valuable contribution. And now I would like to call Assistant Professor Nurbrek Kayrmuhamedov from Astana International University. It seems that Mr. Nurbrek Kayrmuhamedov is not online. If he appeared, we will give him the floor, but now I will open the discussion. Have you got any questions to any of the participants in this session?
If you permit me one remark, taking into account that we have here scientific conference, research conference, international conference, probably it's good to think about some strange theses which were announced. One of the speakers says that national laws of the USA and other countries, Luxembourg was mentioned, is a beginning of reform of the international outer space. I would draw your attention to the fact that no changes in national laws, no new laws can be a start of reform of international law. Because as you perfectly know, international law and national laws are two different systems. And if we open a charter of the United Nations, Article 38, where we have sources of international law, we have treaties, we have international customs, we have general principles of law, and we have also subsidiary sources such as legal teachings and, of course, judicial decisions, but not national law. So probably the reference was made, strange as it may seem, to my colleague, young colleague, Dr. Tolstych, who is working in my department of international law, but I'm not sure that he will recognize that he asserted this phrase. So this is a remark for young students who are participating in our conference. Of course, from the theoretical point of view, no national laws can be a start of a reform. Thank you.
Thanks a lot. Anybody else? Oh, please.
This is not like a question. This might be like a statement, but wouldn't those changes in national laws provoke a political decision to make a change in international law?
They may.
This is a general question, of course. Oh, please. Would you like or me?
Yes, nobody can say that national laws or new national laws does not affect international law. Of course, there is a sort of interdependence between international law and national laws. The same may be said about international space law and national space law. But we cannot say that new national outer space law is a start, is a beginning of a new international outer space law. International law, it's a different system. International law is created by states, only by agreement between states, whether treaties or a practice, customs, and so on. In any case, it is a sort of consent between states. Thank you.
May I please comment on this issue?
Yes, of course.
Thank you very much. Alexander Nikolaevich, I presume that our colleague has meant the trend, not the specific legal, international legal definitions or something else. Because we can say now that the specific national initiatives that were started by the United States have already changed the definitions within the framework of the UN Corpus. The working group has space resources in its name for now, so it has an effect. I understand what you mean. I'm sorry for contradicting to your position, possibly, but I mean that we should not deny the trend. The trend is that these national laws affect the attention of the whole international community to this issue. Only after these national laws, the UN committee has started discussions on this issue. What it would be the result, we don't know. Would it be possible to have an international multilateral regime? It is the question of politics and something else. Would it be possible? We don't know. But the trend we can determine the trend. That is my opinion. I'm sorry if it is not convenient.
Of course, I would like just to add that, national laws, of course, they are based on the political will of that state. However, United States is very, very influential, and they have capacity to pursue their political will in international arena. But this does not create international legal rules. For international legal rules, we need universal practice, or we need some kind of agreement. Concerning the discussion that are now is going on before the Committee of Peaceful Use of Outer Space, those unilateral acts has no legal value in international arena. So, but in that way, providing some unilateral acts, United States of America, as any other state, position itself in that new system and trying to contribute to the development of international space law in accordance with their own interests. So what will happen in the future, what the regime will be established, that depends on the will of many, many other states.
Yes, of course. I think now we have the full picture of the process from diverse sides.
Yes, just in International Court of Justice, as you know, if there is, so to say, one move of one side, then there might be another. Replica, duplica, you know, of course. Yes, I fully agree with the chairman, and I think that that is really important. Since we have the legal audience, Marianne, and I am sure you will agree, it's very good that you are a sort of defending this I believe your friend from Shenzhen University. It's good. I am always for friendship. But the problem is that since we have a legal audience, we should be very precise. And of course, we cannot say that national law is a reform of international outer space law. I agree that national laws might influence, might have consequences. That is, of course, a reality. Also, I would say, if, for instance,
say some words?
If, for instance, it was told that the agreements which were concluded by the United States, Artemis Accord, if these agreements really is a sort of suggestion to reform international outer space law, yes, that is without mistake. Of course, I will have a talk with Dr. Tolstoy. Probably it's a slip of his tongue, not of yours. But in international research conference, we cannot permit such slips of tongue. Thank you.
Dear colleagues, shall I say some words?
Yes, of course.
Maybe it was slip in my English because it's not brilliant, but my purpose was to give attention in the situation that when our international discussion are theoretical, the reality economical go its own way. In my opinion, a similar example we have in Russian history. I mean the collapse of Soviet Union. We saw the Soviet science began to discuss and generate ideas about what to do in the very eve of the death of great power. In this context, it's difficult to overestimate the importance and timeliness of our conference. We need to see what shall we do in legal frame to prevent or to make more how to say, more legal the practice of United States and very strong, powerful economics. Because if you have profit for 200%, it's very, very difficult to prevent the changes in law. I think many countries like China, like United States, could start appropriation of space resources without our decision. We need to prevent it. It's my position, and I show the trend to make sure that we have the power and idea and model to prevent these changes. So if I say a slip in my words, sorry for that, but the trend is very important, and we need to provide new ideas, new technologies, not only in the field of legal science, but in common field of economy, political, and institutional decision. It's multi-level problem. We need to be in multidisciplinary discussion to find the solution for these ideas. Sorry.
Thanks a lot. Anybody else? So this brings us to the end of this session. I will now call you on the recess for about 20 minutes, and then we will have our final, the fourth session, and the chair of the fourth session will be Assistant Professor Dr. Nina Kršljanin. Thanks a lot. Any comment?
It will start earlier than...
Yes. If it is okay for participants for the fourth session, are all present online, or?
We have one colleague.
One colleague here, and.
So could we start at 4 instead of 4:20?
Yeah. So have half an hour.
I think that Maxim Alexejević, I see his name. He is after Petra. Then Marina Muntian. Let me see if she's here. No, but I can send her an email now. And then Polina and Georgi. I will, just a second. Polina, she's here. And Georgi Suvorov. Do we see? Ne vidim Maksima i on je Maksima nego Marinu i Georgija. Sad ću da im pošljem mail. I'll send them an email right now to inform that we are starting 20 minutes earlier.
20 minutes or 30 minutes we will start the fourth session. First to deal with those technical issues and... Yes, of course.
I'm so sorry. I can contact Marina, Marina, Maxim, and Georgi to ask them if they're ready to start.
Može da ih ona kontaktira bolje nego ja. Yes. Thank you.
Yes.
You can. Thank you very much. We start at 4. Thank you.
Easier. Thank you very much.
Thank you. Now it's a time for coffee break.
We don't have coffee, but sad ću pitati da li treba nekom da...